Good morning and welcome to the Senate Executive Departments and Administration Committee of a meeting dated January 27th. Okay, we'll get there. 2022. We're going to open the hearings today by opening Senate Bill 433 and recognizing the prime sponsor, Senator Whitley.
Thank you, Madam Chair. Good morning, members of the committee. It's good to be back in ED&A. For the record, my name is Becky Whitley, and I'm honored to serve Senate District 15, including the wonderful communities of Concord, Pennacook, Henniker, Hopkinton, and Warner. So today I'm honored to bring forth Senate Bill 433 to increase and improve transparency around the state spending of federal relief money. So the language in this bill tracks what was passed in 2020 in HB 1129, and the language in 1129 was regarding CARES Act spending that passed in 2020. So this bill extends the existing requirements for CARES money and expands those requirements to all federal relief funds, including ARPA. So this committee is well aware that there has been a significant amount of federal dollars that has flowed into the state through the pandemic, and I think we can all agree that adopting good transparency practices is especially important now when our government is charged with quickly mobilizing such huge sums of money to tackle the pandemic. I think New Hampshire residents also should be able to easily see where and how their tax dollars are spent around the state. Open and transparent government spending fosters trust that Granite Staters' views and interests are respected and that public money is used well. So this bill will improve transparency and, of course, also make leaders more accountable for their spending decisions. Transparency also supports better fiscal outcomes, we know that, and more responsive, impactful, and equitable public policies. Because of this legislature's limited role in federal relief spending, practices in this bill will promote greater accountability within our body as well. So I'll note just briefly that there's an enforcement mechanism in this bill that I've received some questions about, but I will note that it mirrors exactly the enforcement language in the divisive concepts law that was drafted and passed by the majority in the last budget cycle. So I'll stop there, and thank you for consideration. I'm happy to take any questions.
Thank you very much for your testimony this morning. Are there any questions from the committee? Senator Reagan?
Good morning, Senator. So what do you hope will happen if this is passed?
So basically it's making sure that we have very specific reporting on how the ARPA dollars are spent. And so we already do that with CARES funding. We know that a huge bucket of money came in, it went out really fast. And so this body agreed that, this type of accounting, this very specific accounting in check register format was necessary for CARES funding. We have even more in ARPA dollars. So it's just a way to improve transparency, make sure that everyone in this body and Granite Staters can see line by line how the money is spent.
So your goal is that people can see.
Correct. Transparency.
And then what good thing will happen from this?
The good thing will happen, I think it's a couple things. Transparency, we know, increases the public trust in government in general. That's sort of a well-known principle of budgeting, that transparency increases public trust. It also gives our body, who has sort of limited, control over the money, we can see it also. And I think that informs our decision making. I know I have a number of bills, looking to direct ARPA funding. And so if we have really that line by line spending, we as legislators can know where everything's going and direct the remainder of the funds. Thank you.
Are there any further questions? I have a question, Senator. I believe this issue was a subject of a lawsuit, I want to say last year, when we started getting in the funding and Gopher was up and running, and there was a lot of questions about whether or not the governor had the authority to spend that. Did you consider that ruling when you drafted this language?
I did not, because this really doesn't have anything to do with that. It really has nothing to do with the legislature's role in the spending. All it has to do with how we're reporting out on the spending. So it's a little different.
Okay, thank you. Are there any further questions? Seeing none, thank you.
Thank you. Good to see everyone.
Chantel, can you get a copy of that case and the ruling and make it available to the committee, please?
And I'm happy to send the language from HB 1129 too, as related to the
Okay,
CARES Act
Chantal
funding.
will do that for us.
Thanks, Chantal.
Chantal, can we get the sign-in sheet? We don't have that. Thank you. Okay, are there any other members of the public who would like to speak to Senate Bill 433? Okay, seeing none, we'll close the committee, we'll close the public hearing, and the committee will be in recess until 9:15. The committee will come out of recess, and we are going to open the public hearing on Senate Bill 333 and recognize the prime sponsor, Senator Avard. Good morning, Senator.
Thank you, Madam Chair, and thank you, committee members. For the record, I'm Senator Kevin Avard, introducing SB 333. Very simple bill, it seems. Basically, this bill provides the definition of home health care provider includes a case management agency for the purposes of licensing. I can submit my written testimony in after, but basically, case management agencies have been licensed in New Hampshire for about 28 years by the Bureau of Health Facilities since the initial passage of HEP 819 through the JELCAR on May 27, 1993. The licensure of the agency is critical to ensure that the health and welfare of the citizens they serve. The enabling statute was originally RSA 151-2B, which this bill seeks to amend. The original license issue under HEP 819 stated home healthcare provider case management. And during the course of rules revisions through JELCAR enabled the statutory authority was erroneously changed to RSA 151-2IF, quote F, adult daycare services. And that case management agencies do not provide adult daycare services, and federal regulations prohibit them from doing so. As RSA 151-2B describes, case management entities are engaged in arranging through contract arrangements, nursing services, home health aid services, nutritional services, medical society services, personal care services, and homemaker services to persons in their places of residence or a facility while transitioning to a residence. To deliver case management and receive federal financial participation, FFP, New Hampshire has a state plan amendments, SPA, approved by the Center for Medicare and Medicaid Services, CMS. The choice of independence waivers case management, SBA, requires licensure. This continuing licensure, as the department recommended in October, would eliminate the FFP and cost the state millions of dollars. Additionally, in any case where case management is provided and not licensed or otherwise properly regulated, the state is at risk for millions of dollars in recoupments. It should be noted that 3 of the 4 1915C community-based care waivers, DD, IH, and ABD, are under plan corrections for providing case management services, which are not in compliance with federal law, which requires that the case management be provided in a manner in which requires, I'm sorry, my dyslexia is getting into me, which requires that the case management provides in a manner in which free from conflict of interest. We should be very careful not to eliminate solutions to before a plan and a place to resolve this issue. CMS continues the final rule on conflict-free case management on January 16, 2014. New Hampshire did not bring our programs into compliance and was under the corrective action of CMS February 13, 2017. Present. DHHS has been looking for solutions and has come up short. Several and area agencies have licensed to provide case management currently under HB 19, and this may prove to be a useful tool bringing the other waivers in compliance. And so, Madam Chair and committee members, I do have to go back to another meeting, but I do have some experts that are sitting behind me that can go over this a little bit more detail, unless you have some questions from me.
Thank you very much, Senator. Are there any questions from the committee? Okay, seeing none, thank you.
Thank you.
The chair will call, well, I see there's 2 individuals from DHHS. Would you like to come up together or separately? Okay, then I'll call Nancy Rollins and Doreen Shockley. And you could just bring one of the chairs up. Just make sure before you speak that you identify yourself for the record.
Can you hear me with a mask?
We sure
Okay.
can.
Good morning. Thank you, Madam Chair, committee members. For the record, my name is Dorian Shockley. I am the manager of the Bureau of Licensing and Certification at DHHS, overseeing all licensed programs in the state starting from birth to end of life.
Nancy Rollins, I'm the interim director of the Division of Long-Term Services and Supports.
I'll start by saying we are in support of defining case management agency in RSA 151. RSA 151 does mention case management agencies. It does not define. We do, however, would like to work with the sponsor and others on amending the definition. The definition of case management agency should not be considered the home health agency, as they are very different and distinct. As a matter of fact, our rule HEP 819.14 states that if a case management agency is going to be providing home health care services, they need to be dually licensed as a home health care agency and as a case management agency. Case management agencies, as I'm sure you will hear from folks behind me, will organize and work with others to provide the direct care. We would recommend that the definition in RSA 151 be consistent with the definition in rule. I can cite that if you'd like, or not. And I also want to note that the rules for 819 are half the size of the rules of home health agencies. In addition to that, we have a 100 and, I think it's 100, let me see. The state currently has 104 licensed home health agencies, of which 43 of those are CMS certified, which then brings on another layer of regulatory compliance that case management agencies would have to then contemplate also following if they were going to become CMS certified. We currently have 9 case management agencies licensed in the state. And again, I want to make sure that it's clear that we do not oppose this bill. We are in support of defining case management agencies in law. However, we just want to work to make sure that that definition is an accurate definition of what case management agencies are. And to the point, and I might have misheard earlier testimony or from the sponsor, but we do license case management agencies. We do regulate. So I thought I heard that we were out of compliance with that, but we do license, we do regulate. It's a very different environment than home health agencies.
Okay, thank you. Ms. Rollins?
So the only thing I would add to what Doreen had stated is that we have a simple fix to this, if you will, which is to take the language that is currently in HEM 819 that is approved, that defines what a case management organization is, and add that to RSA 151 in the appropriate place. And I have a letter that was sent to Senator Morse and Representative Sherman Packard that outlines that. I'm assuming you folks probably don't have this letter, so we can make that available to you. But I think it's the way to address it. Part of this is compounded by, we have several other entities that currently provide case management services, such as the community mental health centers, the area agencies, homeless shelters, which was just enacted, family support services to children and young adults with chronic health conditions and so forth. And what we would do is amend those administrative rules so that everything is consistent in terms of the language of what case management agency is.
Okay. Thank you very much for your testimony. Are there any questions from the committee? Okay, seeing none, if you could please make sure to provide those documents to our secretary. We'll make sure that we'll all have a
Perfect.
copy.
Thank you.
Okay, thank you. The chair will call Carolyn Virtue.
Good morning, Madam Chair, members of the committee. My name is Carolyn Virtue. I own and operate a company by the name of Granite Case Management. We provide case management services to individuals seeking long-term care privately and through the state's CFI, Choices for Independence, Medicaid waiver. I would ask the committee not to take references from rule and put them into the statute because that's a little bit backwards. The HEM language that was referenced by the department says that includes, and I'm paraphrasing, I don't have it before me, but it includes references to licensure or prohibitions of licensure to area agencies when in fact many of the 9 agencies referenced that are currently licensed under the HEP 819 are area agencies. So that the language requested would be problematic. So I want to back up a bit to the beginning, and Jeb Carlop can speak to that as well. But I became licensed early on as a case management agency. I previous to that owned home care and hospice agencies. Our original licenses stated home care provider - case management. So any assertion that we were never licensed under the home care statute is false. The other thing that we did do when this discussion came up, and this bill is before you because the department did have a plan to eliminate licensure for case management agencies, and that would have cost the state and the individual providers a great deal of money if they are successful in eliminating licensure. I'm glad to hear this morning that they are back on board in support of it because it is very important. But we also went to OLS and got the historical licensure files. I'm sorry, the admin rule on the licensure, and that also supports that that case management was originally licensed in the statute before you. I believe it was in error that it got switched to adult medical daycare statutory reference, and so we're just asking that that be fixed. I love the department's suggestion of putting an actual definition for case management into this statute. And I would recommend, if you are going to do that, that you use the federal reference because there is one. And it's not very long, and I will provide that to you by the end of the day.
Okay. Please identify yourself for the record.
Yes, Madam Chair. My name is Robert Clegg. I'm with Legislative Solutions, and we're here to help represent Granite Case Management. I just want to give a little background, and that is that case management costs the state money. It costs the state money because it forces the department to actually provide the services that we put in law and that we take money from CMS. Now, in the case of case managers, CMS says that you can't have any conflict. So the people who provide the services can't, are not supposed to be the case managers, unless there are no case managers. And I can tell you, we've seen numerous documents sent to the federal government saying that we're having the same people who provide the services provide the case management, because there are no case management companies in the state. These are two. I think the largest one is sitting behind me, Jeb Kurlop. So there's always been an interest to do away with the people who make sure that the folks that are sitting at home, the elderly, the handicapped, get the services and don't get pushed out. And some of you may remember there was a lady on TV, 94 years old, called Doris, who lost her home along with 13 other people just because they wanted to. If it hadn't been for a case manager, those people would have been thrown out of their houses with no place to go, no family, and nobody would have cared because nobody would have known. But it was a case manager who saw it and fixed it. Case managers have found monkeys on people's tables in the group homes, and nobody cared about from the state except the case manager who turned it in. One guy was punished for complaining about the conditions where he was, so they took away his ability in Manchester to use the bus to go to the library every day. It was a case manager who fixed it. We need case managers. Yeah, they're a pain because they make you follow the rules. And speaking of rules, I've been up here since 1994. There's not supposed to be a rule without a law. So here we are, the department saying, we made this rule, and now we want you to make the law comply with the rule. That's not the way it's supposed to be. It's supposed to be 424 people decide whether or not we ought to have it. They sneak the rules through. In the Rules Committee last week, we saw them state that there was a 3-year hiatus on a rule because they never came back in and renewed it, and sat there and said to the committee, oh, but we didn't deny anybody any services. And while they were saying that, they were texting Ms. Virtue saying, can we have the proof that you have that we were? And she says, look in your records, you were. So what I'm saying here today, as a former colleague, I don't think we should be doing things that they want to skirt what the legislature has said is necessary to take care of the elderly and the handicapped. The bill before you is done so that there's no more confusion. Here's what it is, and you can't change it no matter what you do in rules. The law is going to say the same thing that it's said for years, and we're going to provide the services to the elderly that we said we would provide. Thank you, Madam Chair.
Thank you very much for your testimony. Are there any questions from the committee? Mr. Clegg, the representatives from the Department of Health and Human Services talked about the need for a definition of case management. Do you believe that that's appropriate?
Do we?
Case management is well defined in the governing federal statute and CMS guidance. But we're not always following that, so I don't think it would be hurtful to put that into statute. We have to follow it anyway.
Okay, thank you. Are there any further questions?
Madam Chair, if I may add one thing, and just for the committees, they should speak to Senator Avad, because as of yesterday, Senator Avad was told by one of the attorneys from DHHS that there's no such thing as case management licensing. We actually copied a license to show that there is licensing. So I'm very suspect of any definition other than, if we're going to put a definition in, we should put in exactly what the federal law says, because that's what dictates how much money we get from the federal government as well.
Okay, thank you. Any further questions? Seeing none, thank you both very much. The chair will call Heidi Kroll. Just make sure you identify both before, if you speak.
Good morning, Madam Chair and members of the committee. For the record, my name is Heidi Kroll. I work at Gallagher, Callahan, and Gartrell, and I'm here today representing Life Coping. With me is Jeb Kurlop, principal with Life Coping, and I will let him introduce himself and say a few words about the case management agency that he and his family have been running in Nashua, which has a statewide footprint for 2 or 3 decades. We are here in support of SB 333.
Good morning, Mr. Kirilov.
Good morning, Madam Chair and members of the committee. Thank you for the opportunity to speak this morning. My name is Jeb Krolop. I'm with Life Coping. We are a case management agency providing statewide case management for and to assure that individuals can remain at home independently and safely with services. We provide service to several different populations, primarily the state Medicaid waiver programs, which include individuals who are on the Choices for Independence waiver, which is for the elderly, the adult disabled, and the chronically ill. We provide case management for individuals on the developmental disabilities and acquired brain disorder waivers. We have also provided supports of case management for in-home supports waiver. And the agency was begun in, just for a little background information, in 1994 by my mother and father. My father was a physician, my mother was a nurse, and still is a nurse, and when they started the agency, they basically, they could see on the horizon that a lot of people were going to be needing long-term care services, and they weren't going to accept doing it the way that they did in the past and staying in a nursing home. And so they also were aware of the change in the laws in the U.S. With the Fair Housing Act back in the 70s, and then through in the 1990 there was the ADA law that was passed by George H.W. Bush, and the Olmstead Acts. All of these laws were really part of the whole evolution to allow people to remain in the community and have the same rights to remain in the community that others had, and not have to be required to stay in an institution. And well, there's a place certainly for all of these institutions. We now have a very well-developed system of supports and services in the community for individuals who have a nursing home level of care. And the waiver part of what we do is actually, that is the waiving the requirement that people be in a nursing home. This waiver allows them to remain at home and independently in the community. And so as this whole evolution began in the 70s and the 80s and the 90s, and to give people the right to live at home and in the community, we came up with, but the federal government came up with case management. And really the case manager is the central person in coordinating and overseeing what supports and services an individual needs. So we do an assessment of what their needs are. We then, from there, develop a care plan for them, and from there we find services and supports for them through the many agencies throughout the state of New Hampshire. And so, and we oversee those services, amend them as necessary. And in a nutshell, that's what a case manager does. Of course, over that time in New Hampshire, the state had begun to contract with independent case management agencies like Life Coping, Crotchet Mountain, Granite Case Management, and several others in the state. But the whole idea of, I've been with Life Coping now since 2002. It's actually almost 20 years. And when I began, we were licensed. I've got a copy of our license here if you'd like to see it. In that license, there are references to the RSA 151. I've got paperwork, application as a home care provider, dash case management for the state of New Hampshire that had been sent to DHHS. So these are people that we're working with who would otherwise be in a nursing home. So, I mean, basically, if you look at just considering that, of course, you're going to need people who have medical backgrounds, and we have nurses, we have social workers, we have individuals with degrees in gerontology, we have people with degrees in home care. We have a clinical director at Life Coping who's a registered nurse. She has many, many years of home care experience. And so by nature of people having a nursing home level of care, of course, this is a medical program. In the old days, the program we work on now, Choices for Independence, it was called the Home and Community-Based Care Program for the elderly and chronically ill. And it's now called Choices for Independence, which I don't think really is as clear, but that's what the name is now. But these are people who would be at a nursing home. So in terms of our being licensed, we've been licensed for years. We need some clarification in the, as Senator Avard has sponsored in his Senate Bill 333, we would ask that that bill be accepted, or basically be voted on and accepted as written. I heard earlier this morning references to, well, if case management agencies are going to be covered under home care agencies, then they're going to have to get a CMS certification. I'm not clear that that's accurate. I know that there's reference in the RSA 151, for instance, to adult daycare centers. I don't know of any adult daycare centers that are Medicare certified. Because if they're going to be CMS certified, then it's Medicaid, Medicare. Most of the agencies that we work with, and collaborate with on the CFI program are Medicaid agencies. They do not have to have this CMS certification. So I would take issue with that reference, and I would ask that the committee accept Senator Avard's Senate Bill 333 as written. Thank you very much.
Thank you very much for your testimony, Mr. Kurloff. Ms. Kroll?
Yes, thank you, Madam Chair. I have a handout to provide to the members. So as you've heard, and as Mr. Kurloff was referencing, you know, from our perspective, we see this SB 333 as a simple housekeeping bill. And so the issue is that HHS has recently taken the position that their statutory authority to license case management agencies needs to be clarified. This came, you know, I think as a surprise to us because, as you've heard, HHS has been licensing life coping and similar case management agencies for nearly 30 years, pursuant to both to HHS rules HEP 819, which is relative to case management agencies, and also HEE 805, which is targeted case management agencies. So SB 333 is simply meant to clarify the department's authority to continue licensing case management agencies and essentially maintain the status quo. And as you've heard, I mean, licensure ensures that critical consumer protections and quality of care for vulnerable populations that case management agencies serve can continue. Licensure also ensures that case management agencies are held to the same high standards that are applied to other healthcare providers, and it allows certain case management agencies to be eligible for critical federal grants and other federal money. So we'd like to just quickly kind of walk you through the law and the rules in terms of where things stand and why this, why we think this proposal makes sense. So RSA 151 is the Residential Care and Health Facility Licensing Statute. The phrase case management agencies is only explicitly mentioned in RSA 151:5. That's the section where license fees are listed, and case management agencies are listed under there under Roman 12. The phrase case management agencies is not explicitly listed by name in the list of entities that appears under 151:2. That's the section entitled License or Registration Required. However, case management agencies, in our opinion, are implicitly listed there, specifically under RSA 151:2 Roman 1B, which, and this is part of the handout that I have for you, which refers to, quote, home health care providers as defined in RSA 151:2B, end of quote. And when you go and read the definition in RSA 151:2-B, it reads, and you have it there in front of you, home health care providers means any organization, business entity, or subdivision thereof, whether public or private, whether operated for profit or not, which is engaged in arranging or providing directly or through contract arrangement one or more of the following, and then there's a list of services. And so case management agencies like Life Coping are a business entity that is engaged in arranging one or more of the listed services that their clients need. And therefore, case management agencies, we believe, do fall within the definition. It is our understanding that the HEP 819 rule relative to case management agencies used to, as you heard, reference 151:2B, and at some point the rule was changed in error, and as you heard by earlier testimony, now refers to adult daycare services, which is wrong. Of importance, the HEE 805 rules relative to targeted case management services, in our opinion, confirm that case management agencies are home health care providers. That rule defines case management agency as, quote, an agency that is licensed in accordance with 151:2 Roman 1B. And again, that's the section of law that says a license is required for, quote, a home health care providers as defined in RSA 151:2-B. So in summary, SB 333 is simply adding case management agencies explicitly to the definition of home health care providers in order to clarify that HHS does indeed have the statutory authority to license case management agencies, and we are fully in support of continuing to be licensed. With that, we thank you for your time and consideration, and happy to answer any other questions.
Thank you very much for your testimony this morning. Are there any questions from the committee? Okay, seeing none, thank you very much. Are there any other members of the public who would like to speak to Senate Bill 333? Okay, seeing none, we'll close the public hearing. I know, I don't think it is either. I know, that's what we added it. I know we added it to another bill. We're going to go ahead and open the public hearing on Senate Bill 229. The prime sponsor, Senator Rosenwald, is not available, and we have someone here who is going to introduce the bill. Good morning.
Good morning, Chair and members of the committee. Can you hear me okay?
Yes, we can.
Great. For the record, I'm Jennifer Gallagher, Executive Assistant for Senator Rosenwald, and on her behalf, I'm here to introduce Senate Bill 229, relative to pharmacist administration of vaccines. This bill adds certified pharmacy technicians to the list of healthcare professionals authorized to administer flu and COVID vaccines under the direct supervision of a licensed pharmacist. This is allowed under current federal emergency order and was also authorized under Governor Sununu's emergency orders. Because the state's emergency order has expired, the Board of Pharmacy believes our statute overrides the still existing federal emergency order. So the change to state law to allow this group of individuals to give limited vaccinations is needed. The Board of Pharmacy has a representative here who is able to answer questions. Thank you.
Thank you very much for your testimony this morning. We won't ask you any questions.
Thank you.
The chair will call David Rochfort.
Good morning, Madam Chair. Thank you, committee, for allowing me to speak this morning. My name is David Roscher. I'm the Vice President of the New Hampshire Board of Pharmacy. We actually worked with Senator Rosenwald to get this bill introduced. One of the things that we have noticed as this pandemic wears on is that we've all, in many capacities within the state board, many facets have been called to do things that 5 years ago normally we wouldn't have been doing. And one of those things is the administration of vaccines by certified technicians. And we were through, as the representative we just spoke, through the PrEP Act, through the governor's emergency order, there were opportunities and allowances for certified technicians to administer COVID vaccines. And this was wildly successful to the point where at this point 580 million vaccines have been given across the United States, and of that 580 million, 210 million were given in community pharmacy settings. So pharmacy has really stepped up to that and proven itself to be a valuable component of public health. One of the things that we found confounding as we've progressed through this with the Board of Pharmacy is that through Senate Bill 155 last session, which codified the ability for technicians, certified technicians, to give COVID vaccines, there was silent, inadvertently, I think, silent on technicians giving flu vaccines. I think that this was just so that being said, I think we look at this in the Board of Pharmacy, Senate Bill 229, is really kind of being a cleanup bill. You know, making sure everything is in line to make sense of a lot of this stuff. The CDC has recommended, as we all know, that in addition to getting COVID booster shots, that patients also receive annual flu shots. So what this has done in our state pharmacies is patients come into the pharmacies getting a COVID shot, the technician's able to give the COVID shot, and then the whole process stops until a pharmacist is available to go and now give a flu shot. The legislature here in New Hampshire believes in the ability of technicians, obviously, with the passage of 155 to do it. The legislature believes that they're capable to do it. Over a third of the states in the United States have provisions for technicians to give flu shots and many other types of vaccines. So we don't feel from the board level that there is a safety issue, and we don't feel the legislature feels that there's a safety issue. We just feel like this, with 229, this is an opportunity to kind of sync up some things and make sure there's less confusion and come in line with that. One of the last thing I really kind of want to, and I submitted some notes to you, and I'm not going to bore you by reading them all, but one of the things that I just want to highlight to the committee is the mission of the Board of Pharmacy. We're tasked with promoting, preserving, protecting the health, safety, and welfare of the citizens of New Hampshire by fostering quality pharmaceutical care. That's our mission. We wouldn't be coming here asking for this if we didn't feel this was in line with the mission of the Board of Pharmacy. And furthermore, this isn't a blank check to then send technicians to go doing this indiscriminately. The board will then come along, and we need the law first, and then we'll write the rules to ensure that the technicians doing this are qualified and trained and appropriately vetted to do so. That's all I have. It's kind of, again, we really look at this as a cleanup bill to be consistent with what has already happened in the legislature. And I'd be happy to answer any specific questions that you may have about this.
Thank you very much for your testimony. Are there any questions from the committee? I thought this bill was interesting because I remembered, and I was talking with Senator Kavanaugh, I thought we fixed this because the emergency order ended, and all of a sudden people were showing up at pharmacies. They had scheduled their shots, and you couldn't give them anymore.
Yeah.
So we had to find something quickly and attach the ability for pharmacy technicians to continue to give the COVID vaccine, but we never considered a regular flu
Exactly,
vaccine.
and you know, we've kind of forgotten about flu, haven't we, over the last 2 years? I mean,
Yeah.
that's really hasn't been anything we've talked about for a couple of years, and now all of a sudden, and the reality in community pharmacy, these guys are getting crushed. I mean, there's a crushing amount of people coming into these places, so to have to get a process that works well for COVID shots, then all of a sudden to throw a wrench in it, well, that doesn't work because now we have to do something else with flu. This will help streamline the process. And you know, we could have come here asking for all vaccines, but this is what the immediate need is right now, is flu, and that's where I think we should be addressing this, at least acutely anyway.
Okay. Okay, any further questions? Okay, seeing none, thank you very much.
Thank you.
The chair will call Bruce Berkey. Good morning, Mr. Berkey.
Good morning, Madam Chair and members of the committee. Thank you very much for the opportunity to offer some comments on Senate Bill 229 this morning. I'm here representing the Coalition of New Hampshire Chain Drugstores, and I would agree with everything that Mr. Rochford just shared with you, and would just go a little bit beyond it, if I may. If you look at Senate Bill 229, and I was involved with senators and representatives last spring in amending 155 in order to be able to have certified technicians administer the COVID-19 vaccine. And just after the bill was signed by the governor, I got a call from one of our members, and they said, "How about the flu?" And I said, "Well, there's always next year." So here we are next year, and we think that this bill is very, very good and very, very helpful because, as Mr. Roscher was saying, the pharmacies are inundated. Over 80% of the vaccines that are given in the state are given in pharmacy settings, and so this will be very, very helpful. Just a couple of follow-ups with respect to this being a cleanup bill. I would, on line 12 of the bill, after the word technician, I would move the "or" that had been up on line 11 and move it in after technician, and then add the words certified pharmacy technician, so that it's all inclusive for those for Roman 1 below it. And then the second suggestion that I would have for the committee is that in our efforts last spring to add the ability for technicians to administer the COVID vaccine, we created 318.16F. F will no longer be necessary if Senate Bill 229 passes. And so I would suggest that you put in a repeal of RSA 318.16F. Because this bill would be redundant of 16F as it relates to just the COVID vaccine.
Okay. Thank you very much for your testimony. Senator Prentice has a question.
Thank you, and it actually might be for the Board of Pharmacy, but I'm just going to put it out there right now so we can, because you just talked about repealing F, correct?
Yes.
So F has an age restriction in it as it relates to the COVID-19 vaccine, correct? I'm pretty sure. I got to bring the. I've been searching through these, trying to match them up. What I just want to make sure.
18 years of age or older.
Yeah,
That's
now
correct.
we know that it can go below that. the COVID vaccine.
Yes.
So if we're gonna do this, this has nothing about age in it, and maybe that's just the way to do it. And this can be addressed in the rules, I'm not sure. There's just a little, so there's a
There's a slight disconnect there.
Yeah,
You're right,
that's all.
Senator. And I think that the intent of 229 is to have it be aligned, have it be consistent for both the administration of the flu vaccine as well as the COVID-19 vaccine. And so, I would leave it to you folks as the policymakers to determine whether that threshold should be 18 or not, and perhaps the board would have some input on that.
If I may.
Yes.
I was contacted by one of my a pharmacist within my district early this morning, and I was just trying to sort through what he was talking about. But now I just got another text message, and it explained it clearly. He's fully in support of this. He just wanted to point out that. So I went and looked at the statute. I'm like, okay, maybe we don't need to do it. Maybe we do. But there's an age that's in F, and that's all. Okay. We'll talk to the Board of Pharmacy. You just happen to be the person in the chair when I
Understood.
So finally this all made
When the
sense
text
to me.
came through.
Thank you. Well, the text came through, and then I understood what he's talking about. So
Okay.
thank you so much.
Thank you.
Are there any further questions? Okay. Seeing none, thank you.
Thank you.
Senator Prentice, would you like to have the individual from the Board of Pharmacy come up again?
If there's no one else signed up.
Nope, there's no one else signed up.
Okay.
So we can
It's,
get this
Dan-
clarified.
Yeah. David, correct?
Mr.
I
Roscher.
can answer your questions here, so.
I think you could, so in 318-16F speaks to an age specific for COVID vaccination.
Sure. So first, can I, if I can?
Yeah.
The first section, the first part, he talked about, Mr. Berkey, about adding the or certified technicians. I think I'm safe to say we would agree with that entirely. That's consistent with the mission that I've been given from the board. As far as the age goes, I would really want to bring that back to the board because our discussions thus far have really been focused on allowing certified technicians to give flu shots.
Agreed.
Before I come before you here and start talking about age, I think it would be best if I ran it by my colleagues at the board, but I'd be happy to do that. And I can email the committee, or I could email you directly. That would be easy, very easy for me to do.
Senator Carson?
Yes.
Quick follow-up. I don't know if when we get into the actual practice of medicine, some of this type of practice it's either in rule or it's in some type of policy or protocol that is enabled by rule and ultimately enabled by statute. So the 18 with COVID, probably connected to the state of, that time that we were in. I'm not so sure that we need to be that specific, and that can be worked out from the board down.
I think
to the
that could be,
pharmacies.
I believe, and I'm not an attorney, nor am I in your position, but, I in my experience of 6 years on the board, that would be something that, in historically speaking, we have addressed that in a rulemaking process.
Yeah.
Okay. And as you know, if we do something wrong in rulemaking, GLCAR will tell us, and they'll send it back to us. But based on my experience and what we've done in the past, I would feel comfortable addressing that in rules.
Thank you.
Okay.
All right.
Thank you very much for your testimony. Are there any other members of the public that would like to speak to Senate Bill 229? Sir, if you would like to come forward, identify yourself for the record.
Good morning. My name is Anthony Leonardos. I am a pharmacist, and I'm the general manager of the Pharmacist Prescription Group. So the Pharmacist Prescription Group is the largest independently owned pharmacy group in the state of New Hampshire, operating as the prescription center and Northeast Pharmacy Services. I am here to support provisions in SB 229 that would allow certified pharmacy technicians the ability to administer flu and COVID vaccinations. Northeast Pharmacy Services services over 80 assisted living and long-term care facilities throughout the state of New Hampshire. And every year we are tasked to support our long-term care facilities by providing flu vaccination services, with approximately 3,000 flu vaccinations being given annually. And as you would expect, with the arrival of the COVID-19 pandemic, the need to provide vaccination services becomes that much more important and complex. We were now tasked with providing an additional 3,000 COVID vaccinations, booster shots, as quickly as possible to residents in our long-term care facilities, arguably the most vulnerable of our population. I am sure everybody in this room is keenly aware of the staffing challenges of New Hampshire businesses. We have been confronted over the past few years in hiring pharmacists and ancillary staff. It took a team of 4 pharmacists over 6 weeks to be able to fully vaccinate our residents. The importance of passing SB 229 should not be understated. As staffing shortages continue and the public need for vaccination services continue to rise, utilizing well-trained ancillary staff such as pharmacy interns, certified technicians, and licensed advanced pharmacy technicians will be imperative. And I urge New Hampshire to join Idaho, Michigan, Washington, Utah, Nevada, and Rhode Island in granting certified pharmacy technicians the ability to administer flu and COVID vaccinations.
Thank you very much for your testimony this morning. Are there any questions from the committee? Seeing none, thank you.
Thank you.
Are there any other members of the public who would like to speak on Senate Bill 229?
Before you close it, do you want to do a committee amendment to fix line 12?
Well, I think Senator Prentice brought up an issue about 18 years old. And if you, I think we need to delve into that a little bit, because the existing statute 31816 BI does include to individuals 18 years or older. And so I think we need to have a good discussion about that. And if we're going to repeal it, we're going to have to repeal it everywhere. So we need to just be aware of that.
Yeah.
So.
There might be a technical fix.
Okay. We're going to go ahead and close the public hearing on Senate Bill 229.
This pharmacist had reached out to me last night. We were talking about this and just the great business, the amount of work that they're doing, which has been really helpful. But I wonder if we even have to, because a lot of the practice issues aren't handled, here.
This was done legislatively.
Yeah.
Yep, no, 18. If you look at that statute, 18
It's interesting. Some places we are very specific about medicine, and other places we I don't say we delegate, but we give that authority either through the rulemaking process or through a certain board to do. So that.
Yeah.
Okay. Yeah. Thank you, Senator Carson.
Okay. I'm all set. We're going to go ahead and open the public hearing on Senate Bill 225 and recognize the sponsor, Senator French. Good morning, Senator. Welcome to Senate ED&A.
Good morning, Madam Chair. No, I try to stay away from this committee.
Okay.
For the record, my name's Harold French. I'm Senator from District 7, and I'm here to introduce Senate Bill 225. This bill will eliminate the need for a New Hampshire licensed auctioneer to carry a $25,000 performance bond. I have been licensed as an auctioneer in this state since I was 18. I grew up in the industry, and the industry has changed drastically since the 1970s. Until the advent of the internet, 100% of all goods sold at auction were sold live and in person. All were conducted by licensed auctioneers. Today, perhaps 5% of goods sold at auction in New Hampshire are sold live, with the majority being sold on the internet. The state does not require licensing for those conducting auctions online, as it was determined to be impossible for the state to regulate interstate commerce when dealing with auctions and auction sales on the internet. Since the start of licensing of auctioneers and the requirement of maintaining a performance bond, there has, I believe, never been an instance where the bond was used to settle a dispute. This bill would update our licensing laws, making them more reasonable for the way business is conducted today, and eliminating an unneeded expense and hurdle for those wishing to pursue their goals of auctioneering. Thank you.
Thank you very much for your testimony, Senator. Are there any questions from the committee? Seeing none, thank you very much.
Thank you.
Are there any other members of the public that would like to speak to Senate Bill 225? Okay, seeing none, we'll close the public hearing.
Excellent presentation. Thank you, sir. You had to leave because you went through your desk.
Yeah.
Yeah, that's okay. We'll get it. We're gonna get it. We're gonna get it. Don't worry. We'll get there. Is there, somewhere else to contact Senator Bradley and?
Ava. Yeah, it's unusual for him. 2-8, not usual. Am I on my? Yeah.
We're going to go ahead and open the public hearing on Senate Bill 228 and recognize the prime sponsor, Senator Bradley. Good morning, Senator.
Good morning. Thank you for your patience. I was across the street as HHS is also meeting today. So for the record, Jeff Bradley from Senate District 3. Pleased to be here supporting and introducing Senate Bill 228 on behalf of the physician's assistants in New Hampshire. As I think we all know, they provide valuable services, especially in rural areas where there is less access to medical care. The ability to have functioning and vital physician's assistants in our state is really important. So what this bill does is seeks to make changes to the licensure requirements for them to modernize their practice and bring them into line with what's happening in other states. From what I understand, the success of this legislation, which has been modeled after Vermont, has enhanced the ability of physician's assistants in that state. So this legislation, Senate Bill 228, is modeled after that, and I just want to, at this point, thank the co-sponsors of the bill and thank the folks that have worked with the physician's assistants to try to refine this bill and make it a consensus, hopefully bipartisan bill that can move forward. Steve Alexos, who is the president of the New Hampshire Society of Physicians Assistants, is here. We're going to let him walk through the bill step by step, but let me just sort of hit some of the high points. Currently, there's a legal tether between a physician and a physician's assistant. This bill doesn't remove that. And it doesn't allow a physician assistant to practice independently. This was an important provision to the Medical Society, the Hospital Association, and I think it's been something that's been worked out. It also is intended not to absolve physicians from liability if they have involvement in the care of a patient. There may be further proposals that will come from Marissa Chase and her organization, I think, that are reasonable and should be considered to make sure we have a level playing field and patients are protected. So the bill, it has 5 different components, and the first one is that it protects the legal requirement that a physician and a physician assistant have a supervisory agreement. It has to be on file with the Board of Medicine, and it combines the standard of a healthcare employer procedure of having that agreement in place. And it creates what in this bill is called a collaboration agreement. The collaboration agreement contains, among other things, how a physician assistant must consult with physicians and caregivers based on the actual condition of a patient. This collaboration agreement will have to ensure that there's at least a signature of one licensed physician and the PA, just as supervisory agreements do now. The collaboration agreement has to be kept on file in the place of employment, and so it's obviously available for inspection by the Board of Medicine. The second key component is the bill makes clear that physician assistants are liable for the care they provide, and it doesn't indemnify, the bill does not indemnify physicians. Again, I think you're going to hear some testimony on the liability issue, so I'll leave it for others to further outline that. It does allow physicians' assistants, and I think this is a critical component of the bill, to directly bill public and private insurers for the care they provide. So that, I think, as I said, is a key provision. the bill and the amendment, which I think you should have, makes clear that this provision would only be allowed when it's permitted by federal law and only when appropriate based on a physician assistant's employer setting, depending on where their actual place of employment is. The bill fourth stipulates a physician assistant does not need a collaboration agreement during an emergency or a disaster. We've seen that come into play during the COVID situation. So I think that's a reasonable provision of the bill. And lastly, a physician assistant does not need the collaboration agreement to volunteer at places like summer camps, charity, road races, and that kind of similar activities. So, as I said, Mr. Alexos can go into greater detail when he talks. And lastly, again, let me thank all the people that have worked on this bill. This will take healthcare to more access and affordability, especially in the more rural areas of the state that have trouble attracting physicians, have much more limited hospital care, and the need for these practitioners, I think, is pretty significant. It also will provide, in many instances, lower costs services for healthcare, and again, given the high cost of healthcare, this is pretty important. So, thank you very much. I would answer questions, but you may want to ask Mr. Alexos.
Okay, thank you very much for your testimony, Senator. Are there any questions from the committee? Okay, seeing none, thank you very much.
Okie doke, thank you.
The chair will call Steve Alexos.
Good morning. Thank you, Madam Chair, members of the DNA Committee. My name is Steve Alexikos. I'm the current president of the New Hampshire Society of Physician Assistants. I'm a Dunbarton resident, New Hampshire native. I've been practicing in New Hampshire at least for 19 years. The NHSPA represents over 1,000 PAs in New Hampshire and 100 plus PA students in the two state-based PA programs. The NHSPA supports SB 228 and the amendments proposed by Senator Bradley, and I thank Senator Bradley and our co-sponsors here today for introducing this bill. I would like to also thank the Medical Society for collaboration on preparing this bill and for the supports of the amendments as proposed, as well as many other healthcare stakeholders such as Convenient MD, Amoskeag Health, which is a urban public health center, North Country Healthcare Alliance, Dairy Medical Center, to name a few. I'd also like to thank other stakeholders that provided important feedback, such as the Hospital Association and the Board of Medicine. Senator Bradley did an excellent job introducing the bill, and I'd like to get in a little bit more detail, while also not taking up too much of your time, but in an attempt to address any questions or concerns that may come up. First of all, the primary purpose of the bill is to decrease regulatory and administrative burdens on the healthcare system as it relates to PA utilization and to help increase access to care, which has been the trend nationwide and especially in New England, with Maine, Vermont, Rhode Island, and our other neighbor, New York, having passed significant PA modernization legislation in recent years. I guess I would continue by talking a little bit about, in broad wording, what the bill does and what it intends to do. Essentially, we are looking to move and combine regulatory language with current statute and have it move into the statute to codify it there, which is, again, nationally speaking, is overwhelmingly how PA oversight is regulated. And we would do, in big part, one big piece is that current regulatory language calls for what's referred to as a registered supervising physician and a practice agreement. The registered supervising physician has to be submitted on a piece of paper to the Board of Medicine. The practice agreement stays at the practice level only. And what we're looking to do is align with, again, regional national trends to combine these into something called a collaboration agreement, which would be kept at the practice level. And this has been discussed with all the stakeholders, and all of which are very supportive of this more modern concept. And again, decreases regulatory burden, administrative burden on not only employers and PAs, but also the Board of Medicine, who has for years compiled massive stockpiles of these forms that rarely, if ever, are used. They're an investigative body that can investigate after the fact, and because of licensing processes, the Board of Medicine knows where PAs practice, and they will always have access to this collaboration agreement. It has to be available upon request. So it's essentially restructuring the paradigm of PA oversight into the statute and just keeping it practice-based. With regard to liability, the liability issue, PAs have always and are currently and have always been liable for the care they provide. And however, under the current framework, simply because a physician is named as a registered supervising physician and signs that piece of paper, the way that the current framework reads, they would be liable for every action a PA performs, even when they aren't actively involved in the care. For example, in large healthcare teams, PAs are for everyone's benefit. PAs are work autonomously within the healthcare team. We aren't independent per se in the traditional sense, but we work autonomously and we provide care as PCPs. So a patient's primary care provider can be a PA. We work in large in-hospital groups and so forth. So autonomous care is provided by PAs. And in the instance where a registered supervising physician isn't actively participating in a particular encounter, that physician could still be dragged into something that they knew nothing about on that given day. Now, there may be physicians that were consulted with actively, and these provisions and amendments would not indemnify any physician who has active participation in the care in question. So it's in simple terms, the simple act of signing a collaboration agreement as a participating physician does not by itself cause liability towards that physician, only if they're actively participating in the care, which again is the modern standard of PA oversight, and we're just aligning with regional and national trends. Furthermore, PAs do always, which is the wide industry standard for any healthcare provider, carry liability insurance. It's all but impossible for a PA or any healthcare provider to practice without liability insurance. It's required for credentialing purposes at any healthcare facility for any insurance company, and it is just the industry standard across the board. Moreover, there is no existing law or regulation in New Hampshire requiring that any healthcare provider carry liability insurance or adequate liability insurance. There's no such language in the statute, and for the purposes of this bill, we're looking to decrease regulation and make it more streamlined, and any introduction of such language would have much broader consequences across the statute for every type of healthcare provider. And our position is that to introduce new language that doesn't previously exist would most likely be best introduced as a separate bill by any interested parties. For the purposes of our bill, we don't think that would be appropriate. I know that Senator Bradley did introduce some amendments, and with the committee's permission, I can run quickly through them just for the record. Is that okay? Mm-hmm. So on page 1, there's an amendment number 2022-0314, lines 1 through 10. Those were simple drafting error corrections. Page 1, lines 12 through 31, mostly restates what's already in the bill, but makes some small changes sought by the Board of Medicine. So it was a chunk of language that was transposed as the amendment, but really there's a very small wording changes in that parcel of language. Page 1, line 19, makes clear that a collaboration agreement must be signed by a New Hampshire licensed physician, not just a licensed physician, as was the previous language. It was just a small language correction. On page 1, line 21, the amendment, it amends the word and replaces the or between appropriate physician and other healthcare provider to clarify the intent of that paragraph, which necessitates that a physician has to be involved or has to be available, but it can also include other healthcare providers as part of the team. On page 1, lines 27 through 29, the paragraph is restated to make clear that a physician is available for consultation at all times when a PA is practicing. It doesn't have to be the participating physician that signed the agreement, but a physician as part of the collaboration agreement, and protocols for such things would have to be included in the collaboration agreement. On page 2, lines 6 through 10, this is the language I referenced earlier to make it clear that PAs are responsible for the care they provide, but that physicians would still remain otherwise liable for the care that they individually provide as well, or collaborate directly in with the PA on that instance. On page 2, starting on line 15, the amendment restates the volunteer language in the bill, but repeals a small statement that it is the obligation of PAs to carry adequate and appropriate liability coverage when providing volunteer care. As previously mentioned, this was actually a small drafting error. It was a part of an earlier draft that made it to legislative services before we could make the correction. And again, this does not align with New Hampshire current statute, and we are not looking to introduce new concepts that could have ripple effects throughout the rest of the statute as it relates to other healthcare providers. And again, it is widely long-standing industry practice that any healthcare provider carries a liability coverage of for any type of care provided. Page 2, lines 25 through 36 restates the language regarding direct billing and payment. Direct billing is a concept that is a Medicare concept, and as of January 2022, Medicare corrected a longstanding issue where PAs were the only provider type with an NPI number, which is your national identifying number, that could not accept direct payment from Medicare. It had to be done through their employer, but this corrects that oversight, and now PAs are federally allowed to accept direct payment as long as it's consistent with state laws, and this is to align our state language with the federal language so that there's no ambiguity. And lines 32 adds the words "when appropriate" to address concerns of some healthcare employers that had some concerns about billing under the physician, under the PA's name, when there are other Medicare sanctioned billing strategies that can be used, and it may not always be appropriate to bill under the physician assistance number, name and number, but when it is, this language encourages that practice. But it gives a little bit of a qualifier to allow for federally sanctioned billing strategies that can otherwise be used. And with that being the end of the substantial amendments, I'm happy to take any questions from the committee.
Thank you very much for your testimony. Are there any questions from the committee? Seeing none, thank you very much.
All right, thank you all.
The chair will call Holly Haynes. he's not here. No, I don't have you on the list. Yeah, no, you're not on the list. So we'll have you up next, okay? Good morning, Ms. Haynes.
Good morning. Thank you, Chairwoman Carson and Vice Chair Reagan and members of the committee. Thank you for letting me testify today on this bill. My name is Holly Haynes. I am an attorney at Abramson, Brown & Dugan in Manchester, New Hampshire, where I practice medical malpractice law, and I represent patients who are catastrophically harmed by the negligence of others, including physicians and physicians' assistants. I'm also the past president of the New Hampshire Association for Justice, where we represent citizens. Our mission is to protect people's access to justice, preserve their constitutional rights, and make sure that they have their constitutional right to a remedy when they are harmed by the acts of other people. I'm also a resident of Ware and a New Hampshire native, and I'm honored to be before the committee today. We've had extensive discussions with all of the stakeholders involved in this. Initially, when I reviewed this bill, I had a lot of mixed feelings about it. I had significant concerns about patient safety, but after having conversations with all of the different stakeholders, I believe that we've come to agreement on many things, including one of the suggestions that I made in my testimony to adopt the complete language of the Vermont statute on physician liability for physician assistants. So that portion or that request in my testimony doesn't need to be addressed. I believe everyone agrees on that. My largest concern, however, is the insurance coverage requirement and requiring insurance coverage for physician assistants. Before I get to that, I would like to address just a couple of comments by the previous speaker, which will segue into my concerns about the insurance coverage requirement. The previous speaker said that all stakeholders are in favor of this bill. It's my understanding that that isn't the case, that there are stakeholders with significant concerns, including the Office of Professional Licensure and Certification, OPLC. I understand that there are concerns, just as we have as at the New Hampshire Association for Justice, of the lack of board oversight of physician assistants if this bill is passed. We have a lot of concern about that. By taking out the requirement that the physician, the collaborating physician, be registered with the Board of Medicine, it takes out board oversight. There are a lot of things in the former statute that kept board involvement, and this new bill removes that entirely. That's not something that we are taking a position on. We just have concerns about that. And I understand that OPLC may have some of the same concerns about the lack of supervision. PAs were never intended to act independently. Physicians are, they don't have the same training requirements, they don't have the same education requirements, and I understand that they want to be able to practice independently, have more autonomy, but there have to be restrictions and they need to remain tethered to the physician, so there is some safety net for patients who have complex problems that may not be recognized by a physician's assistant as they would be by a physician. One other comment that was made by the previous speaker is that it's all but impossible to practice in the state of New Hampshire without professional liability insurance, and this is going to segue into my comments. I respectfully disagree. That is certainly true for hospitals. Almost every hospital does have a mandated minimum of professional liability coverage of $1 million per claimant and $3 million per incident. The same is true for most group medical practices, but it's not true for ambulatory surgical centers. It's not true for standalone practices or solo practices. And it's my understanding that there's currently at least one physician assistant who is self-employed in a solo primary care practice at this point in time. And with this bill, we expect that there will be numerous physician assistants that will be self-employed, opening up primary care practices. There's no doubt that we need more primary care providers in the state. We're in a healthcare crisis, we need more, but physician assistants should be tethered to a physician. If they're in a collaboration agreement with a physician who is not in their practice, who's not in a hospital, who's not in a group practice, it's very difficult if there's a patient there, there's no physician there they can call on to lay eyes on the patient if the patient has a complex problem. That's really our biggest concern, is that we're going to see all of these solo physician assistant practices opening up with no doctors on staff and no doctor there to assist in the event of a problem or a more complex patient. The collaboration agreement isn't going to solve that. While they may be able to pick up the phone, a physician can't give medical advice over the phone if they don't lay eyes on the patient if there's a complex problem. So that is a major concern. And the lack of coverage, we have a case right now involving a CRNA who doesn't have sufficient coverage because an ambulatory surgical center just required some coverage. It didn't have any requirement for adequate coverage. And some coverage can be any amount. It could be $25,000. It could be $100,000. The CRNA has caused the death of a young woman who was working, and I'm sorry, but $25,000 or $50,000 or $100,000 just doesn't reflect the value of a human life when that's taken away. And I don't think that's adequate coverage. We need to make sure there is adequate coverage. I know that one of the main goals of this bill is to place physician assistants on parity with physicians and nurse practitioners who are practicing independently, and I absolutely agree. There are no requirements in statute or for licensing for them to have professional liability coverage. By adding a requirement for professional liability coverage to the collaboration agreement, it maintains that parity completely. It would not make it a requirement of licensing, so it stays on par with physicians. It stays on par with nurse practitioners. And the collaboration agreement itself is something that isn't required by all of those other healthcare providers. It is a unique creature because physician assistants are a unique mid-level healthcare provider. And by making it just one added requirement in the collaboration agreement, we maintain parity with everyone and we protect patients who may be harmed by negligent conduct, and will also protect physicians who may later be found on the hook for negligent conduct if, under the collaboration agreement, there is vicarious liability of some sort. This way the PA would have adequate coverage. I would think that doctors would be in favor of this so that they could not be brought into a lawsuit to try to access their coverage. Insurance is a touchy subject. No one likes to talk about it. No one likes to talk about lawsuits. No one ever wants to have or pay for a lawyer or pay for insurance until they need it. And by adding this to the collaboration agreement, it will be there when they need it. I don't think there is going to be any overwhelming flood of claims where this is going to be a problem. And as the previous speaker said, it's already required by all hospitals for credentialing, and it's already required by group practices. This will just make sure that it's required in those solo practices and places where physician assistants won't have the same supervision or contact with or just capability to involve a physician. Those are our main concerns, and my suggestion in my testimony is just that in the collaboration paragraph, which is, bear with me, RSA 328D3B2, I would simply suggest that we add a subpart E to the collaboration agreement requirements, requiring that physician assistants carry adequate professional liability coverage in an amount satisfactory to the collaborating physician. So if the collaborating physician feels that a lower amount is possible, that's fine. But with minimums of $1 million, $3 million, consistent with what's required by hospitals now. That's all that I have. I thank you for listening to my testimony, and I will take any questions that you might have.
Thank you very much for your testimony this morning. Are there any questions from the committee? Okay. Seeing none, thank you very much.
Thank you very much.
The chair will call Senator Sherman.
Thank you, Madam Chair. And for the record, my name is Senator Tom Sherman. representing District 24 on the Seacoast. I come today in strong support of the bill with the amendment. And I just wanted to add that what we're seeing is that this is happening nationally. As the chair knows, we've worked with Linda DiMartino and the PAs and the Medical Society, really watching and going alongside all the changes in how physician assistants can practice. We've expanded their practice into psychiatry. We've really rewrote the statute a couple of years ago. And what this does is it brings us up to the same level as our neighbors. So Vermont, Maine, Rhode Island, which is not our neighbor, but it's pretty darn close. And if we do not move forward with this legislation, especially the type of practice that it envisions, which is not independent practice, I agree with Holly completely. We're not looking at independent practice, but we are looking at the way PAs practice currently. In my practice, the PA functions very much as a colleague, but always she has access to one of us if she has questions. In my practice in Virginia, where we had 10 physicians, we had similar assistants and a similar relationship, and that was 13 years ago. So really, we are coming up into the evolution of the practice, and this allows us to be competitive to attract, recruit, and retain PAs in the state of New Hampshire, which I think we all recognize the workforce challenges in the healthcare field. I do share a concern. I think part of the protection of patients is having adequate liability. I would never dream of practicing, and I was in a private practice for many years, always carried $1 million, $3 million. It was just part of the deal. That was what we had to do. You can do everything right, as Senator Prentice probably knows as well. You can do everything right and still have a lawsuit. And if you aren't protected, if you aren't carrying liability insurance, then you've not only hurt your patient, but you've doubly hurt your patient because they can't seek appropriate compensation. Fully support the bill with the amendments and with the comments of the previous speaker. I would take that into serious consideration. And thank you. I'm happy to answer any questions.
Thank you very much for your testimony, Senator. Are there any questions from the committee? Seeing none, thank you very much.
Thank you.
The chair will call Mike Padmore.
Good morning, Madam Chair, members of the committee. My name is Mike Padmore. I'm the Director of Advocacy with the New Hampshire Medical Society. I'm here to speak in support of SB 228 today. I'd like to just start by thanking the New Hampshire Society of Physician Assistants for coming to us in the fall last year just to discuss this bill. We've worked very closely with the PAs over the last few years to make changes to statute and rules, such as removing ratio requirements for PAs, removing the need for a PA to have a registered supervising physician prior to licensure. We really hope to achieve that same effort, that same collaborative effort in this bill. So first, the first item we really looked at was we wanted to make sure, and it was critical to us, to ensure that that legal relationship between the physician and physician assistant was retained in statute. We do believe that that was achieved by the language in these collaborating agreements. To inform of the current law, a participating physician must hold a New Hampshire license and also be licensed in the same specialty as that PA. Second, we do support that physician assistants be responsible for the care that they deliver. We feel it is important to include language in statute that a participating physician would be liable in clinical situations where they are participating in that care with that physician assistant, but however, not liable when they are not in consultation with that particular physician assistant. And then finally, we do support PAs being able to bill for the care that they provide. In getting feedback from some different folks and other entities, I think we felt it was appropriate to leave that decision to the practice or the employer to essentially however they handle those billing decisions. And we think that that item was probably achieved in the amended language that you all have in front of you. So with that, I thank you all for your time, and I'm happy to answer any questions that you might have.
Thank you very, very much for your testimony. Are there any questions from the committee? Okay, seeing none, thank you very much. Are there any other members of the public that would like to speak to Senate Bill 228? Mr. Cuzzy, would you please come forward?
Thank you, Madam Chair. I didn't intend to speak, but I just wanted to, for the record, my name is David Cuzzy with Prospect Hill Strategies here in town. Today before you on behalf of the New Hampshire Society of Physician Assistants. As Ms. Haynes previously indicated, we've had extensive conversations with them, and but I did want to clarify a few points that she did make. This bill does not at all change the regulatory oversight of PAs. The only thing this bill would change is that instead of sending what is now the RSP form to Concord, where it goes into a file cabinet, that now would be, of course, combined with the practice agreement into what the bill would create as a collaboration agreement and be kept on file at the place of employment, as the practice agreement is now. The Board of Medicine currently does not approve or deny RSP arrangements. The form is simply sent to Concord where it is filed. So that is the only change. The document just would stay with the practice, which the practice agreement currently already does. Current regulations, there was concern expressed that this bill would allow for consultation with a physician who may not be physically present. That is allowed by regulation now. The responsible physician does not need to be present physically. They only need to be present, and that could be any, per the practice agreements that exist now, that could be any physician needs to be present, at least electronically at all times. Obviously, if there's a situation that is outside of the PA's training or education or experience, they must seek other consultation by someone either there or referring someone to an emergency room, for example. Again, I think the discussion regarding liability coverage is not an unreasonable one to have, but I think for the reasons that Senator Sherman mentioned, Mr. Padmore and Mr. Alexakos, I would respectfully suggest, and I don't say this to be flippant, but the physician assistants believe that it is largely a solution in search of a problem. As Mr. Alexakos stated, there is no, because nothing is really changing at all, other than submitting a piece of paper to Concord, all of the regulations governing and laws governing PAs remain the same. We're taking the RSP, we're taking the practice agreement, we're making it a collaboration agreement, and instead of sending it to Concord, we're just keeping it at the place of employment for inspection. So Mr. Alexakos mentioned that PAs already have to carry liability insurance. It's either, or they don't have to by law, but as Senator Sherman indicated, anyone would carry liability insurance. No physician would enter into an RSP with a PA, or in this instance, a collaboration agreement, without the PA having adequate insurance. Employers typically provide liability coverage for PAs, and the overwhelming majority, 99% or more, of PAs in the state are employed by healthcare employers, healthcare systems, or large primary care practices, surgical centers, the like. If they're not, if the coverage is not provided for them, then that coverage is, then PAs must show proof of coverage to the employer. And as Mr. Alexikos indicated, there are requirements for payers, health insurance companies, regarding liability coverage. So we think that because we're not changing any of the regulatory regimens, because New Hampshire law does not require coverage right now explicitly in laws or regs for any healthcare provider, we don't know that we really need to start now. But if that's the decision of policymakers, we think that that would be a discussion that should involve all healthcare providers. The other concern is that the definition of adequate, I know Ms. Haynes, suggested a level. I would suggest that, again, this might be a bigger issue, best taken up on separate legislation. Putting something like that in statute, as we all know, prices increase over time, and so that would require frequent legislative fixes and gets into a whole set of issues that really, I would respectfully suggest are outside the scope, especially given current practice here in New Hampshire. That said, of course, Madam Chair, as we've seen based on the testimony today, we're always happy to speak with folks. The goal is obviously to get everyone a yes, but on this issue, we think that it might be best dealt elsewhere. I would say also one other clarifying point. Mr. Alexikos in his statement did not say that all stakeholders were in agreement. He mentioned those who have indicated support by letter. The Hospital Association or the Board of Medicine or OPLC have taken any position. He simply said that nor has Ms. Haynes' organization. We simply said that there's been positive feedback on the bill. Regarding OPLC, we spoke with Ms. Courtney on Tuesday. We had a nice discussion, and I'm certainly not speaking for OPLC, but the feedback we got was that they had no position on the bill. They didn't see the need to take a position on the bill because, frankly, there really wasn't much in there that was impacting them, and I think I've outlined the reason why. The Board of Medicine had extensive conversations at their open meetings. We participated in those. They addressed two concerns which were fixed, and they are neutral right now, and I don't know if they'll choose to vote to support the bill at some point in time. Again, I'm not speaking for them, just for context. And those are the points. Other than that, this again, this language is very similar, especially to Vermont and to a somewhat lesser extent Maine, and they are not experiencing any issues. The system, this seems to be working well in those neighboring states. I appreciate your indulgence, Madam Chair, and I'm happy to answer any questions.
Thank you very much for your testimony, Mr. Cuzzy. Senator Prentice has a question.
Thank you, Senator Carson, and good morning. Thank you for standing up and providing your testimony. So I'm curious what you're saying is there. So there's a higher. We're seeking out to modernize PA practice. I'm a co-sponsor of this bill and match up with what our neighbors are doing, relying largely on Vermont. And there's a level of independence that comes with it, but the physicians and the PAs are still tethered. They're this collaborative agreement. But when it comes to the liability insurance, you don't think that there should be an exact prescription for, say, 1 million, 3 million? We shouldn't dictate what that coverage is. We should leave it up to the PA,
well,
or the practice. Help me with that.
Yeah, thank you for the question, Senator. Right now, there are no current law regs do not dictate that there's even coverage, let alone define adequate coverage. And so what we're saying is we're not necessarily seeing a reason to change that. But if the legislature thought that it was best to put some sort of a requirement in law, either if there's coverage or if there's adequate coverage, and define that, we would respectfully suggest that that would be uniform across all providers, not just PAs. We're not sure why only PAs would suddenly have that requirement put upon them, especially given that the regulatory environment or will not be relaxed in any way, except for the fact that we're sending a piece of paper, not sending a piece of paper to Concord. Did that answer your question?
Yeah. Yes.
Follow up?
Thank you. Yes, it does in large part. I think we probably both realize that there are there's like catch-ups that that happen when
Sure.
a proposal comes forward. You have the opportunity to look at it and you say, well, this change, maybe, if we're going to make it, we should make it for everybody. And then there can be, a legislator who picks that up and works on the policy issue throughout. So it doesn't, what I hear you saying is it hasn't been, maybe it doesn't need to be, but nobody else is held to that. So why are we holding PAs to that? So,
I think you said it better than me, Senator. Thank you.
So it's going to, I think what you've done though, but is and some of the others who've talked have raised the issue, like, is this the opportunity to look at it? And I wouldn't just look at it for PAs. I would look at it for all, not to make it harder, but to just protect everybody across the board. So I don't know where this will ultimately end up going, but that's what I was looking for clarification on.
Yeah.
Thank you. You did a nice job.
Thank you. Thank you. I hope the PAs heard that. So, if I may,
Yes,
Madam
please.
Chair. So again, we're happy to have that discussion. I would be, respectfully, I would be concerned if we look to have that discussion now, because that is quite a can of worms.
Yeah.
And so I just wonder if, if not to presuppose an outcome, but if we're fortunate to get a positive recommendation from the committee and this bill passes the Senate, I would make the same argument over in the House. But again, the specific change that Ms. Haynes suggested, it really just deals with, a line in the collaboration agreement. We're not, and that, though, again, opens up a big can of worms. I don't want to make it seem like we're dug in or that we're being stubborn in any way. We're happy to have that discussion. And if, especially if we see that we don't want to cut off our nose to spite our face. But I do think that it would only be fair to the public and others to have that, and all providers to have that discussion in a more robust way, on a different legislative vehicle, if you will.
Follow up?
Quickly, this may be better dealt with in rulemaking, from a rulemaking capacity. I can speak to at least one other practice where it's not about the individuals, but the organizations themselves. It is prescribed in rule what they have to carry for insurance, which comes to emergency medical service units, which are the agencies that provide. That is prescribed as, I believe it's 1 million, 3 million, but it's in rule, it's not in statute. So maybe that's if indeed this can of worms opens, that might be the better way to pursue this.
If I may, Madam
Yes,
Chair.
please.
Yeah, not taking a position one way or the other. At the very least, that would provide some flexibility as costs go higher. But again, if we'd like to see said can of worms maybe dealt with on another bill. Thank you.
Thank you. Okay, are there any further questions? Okay, seeing none, thank you very much, Mr. Cussy.
Thank you.
Are there any other members of the public who would like to speak to Senate Bill 228? Okay, seeing none, we're going to close the public hearing. Okay. We are concluded our business today. Thank you all very much.